Hello again, everybody. This is Barbara Jennings with Towne Benefits, and I want to welcome you to our most recent webinar that is on the topic of legal protections for employees with disabilities. I kind of expanded the subject matter once we had already sent out our materials for the webinar, because I realized that if we're going to cover things about the Americans with Disabilities Act, I think we also should include the legislation regarding pregnancy and lactation protections as well. And so the subject is a little bit more expanded than originally anticipated, but I think it's things that you really would need to know. As many of you probably know, I am the human resources consultant with Towne Benefits, and I very much enjoy interacting with a lot of our clients. And so I welcome everybody today. And just to let you all know that anytime I get a phone call asking for some help, that I really do enjoy those interactions. So hopefully you'll feel free to call me or call Corbin on compliance matters, and we kind of tag team folks and try to get you answers that are, comprehensive. Many things in the HR world kind of spill over into the compliance world. So just a quick background, I have been in the human resources field for, probably about 40 years. Spent 33 of those years in human resources management. Most of my career has been spent in law firms, banks, and insurance companies. So I do have a variety of experience, mostly in those fields. But as you know, much of HR applies no matter what type of company you work for. You have some basic things that every HR person needs to know. Now, I always have to give you the disclaimer, and that is, remember that I'm providing this information to try to get you kind of thinking in a common sense way, to give you some good information, maybe fill in some gaps on things that you don't know and wish you did know. But nothing that I'm going to say today is legal advice. I'm not a lawyer, and so I cannot give you legal advice, and nor am I a tax professional, so I cannot give you any type of tax advice. And so nothing here is supposed to be construed as either one of those things. So hopefully, though, you'll come away with some information that you have found helpful. So we're going to start with the Americans with Disabilities Act. And I know we've all heard of this act, and it does affect many companies' daily lives. And this legislation has been around for about 30 years, I think. And it was amended a few years ago to really make it broader. And companies may not come into contact with the Americans with Disabilities Act a lot. Just periodically, you might have somebody, either an applicant or an employee or somebody that you have to figure out how you're going to deal with the situation when you think someone is disabled or when someone has asked for an accommodation. So the Americans with Disabilities Act, it is a federal civil rights law. And that means that because it's at the federal level, that means it covers all 50 states. And it prohibits discrimination against people with disabilities in everyday activities. Now, the whole act has 5 titles, 5 sections. And we are concerned today with Title I, which has to do with employment, and Title V, which has to do with retaliation. The others, I'm sure if any of you all also do facilities management at your companies, you also are probably aware that the ADA, you have requirements as far as stairs and accessibility and doorway widths and hallways and that sort of thing. We're not going there today. We're just interested right now in employment. And the ADA, because it's a civil rights law, it is pretty much just like the prohibition against discrimination on the basis of race, color, sex, national origin, age, religion, pregnancy, that sort of thing. And it guarantees that people with disabilities have the same opportunities as everyone else to enjoy employment opportunities, to purchase goods and services, and to participate in state and local government programs. So I'd like for a minute to ask you to kind of open your mind about the ADA and everything that you know about it, and think about the idea of providing people with disabilities the same opportunities. And I think it helps to consciously think about enabling people who are otherwise qualified, but who may have some disadvantage as far as their disability, that we are simply trying to aid those qualified people in being hired for jobs for which they can fill. And so not to think of it as a negative thing or something, oh my gosh, we have to do, but that this is something that we could walk away with a really good employee and the employee could walk away with a good job. And that's kind of the way to think about it. You'll probably hear me say that again while we're meeting today. All right, now the employers that are covered. Now this is a little bit dicey because the Americans with Disabilities Act, as we said before, prohibits discrimination on the basis of disability. And Title I makes it unlawful for any employer with 15 or more employees. And that includes the governments, the state and local governments, to discriminate against a qualified applicant or an employee because of a disability in any aspect of employment. So that means when you're talking about the aspects of employment, you're talking about everything from the job ads that you run to the candidates that call you or send you a resume, to the interview process, and then once people are employed, it applies to your employees as well. So it's broad in scope as far as from beginning to end of the employee relationship. Now, in addition to protecting qualified applicants from employment discrimination, there's also this interesting piece that talks about the association provision that protects applicants and employees from discrimination based on their relationship or association with the individual with the disability, whether or not it's the applicant or the employee that has the disability. And this is when I said, close your eyes for a second and open your mind to think about this whole law. This really makes sense. What this is saying is, if you happen to know something about somebody, an applicant or an employee, about the fact that they may be related to or have a relationship with someone who has a disability. For example, you learn through an interview perhaps that the applicant discloses that the spouse has multiple sclerosis. That might make you immediately think, oh my gosh, this person has caretaking responsibilities. They're not going to be a reliable employee. Or if you have somebody for like, they have a child that has special needs, and that might make you go, oh, same thing. Oh my goodness, I'm not sure I want to take a risk with this employee. Well, that's a form of discrimination that is prohibited by the ADA. So just be aware of that you can't bounce an otherwise qualified person out of consideration simply because they have a relationship with somebody who has a disability. Now, you see down in the right corner, I've put down there this little sentence that really has a lot of meaning. It's in Virginia in particular. Virginia has disability laws that apply to employers with more than 5 employees, okay? So we're going to talk about those a little bit later, but be aware that for many disability discrimination issues, you're talking about employers with 5 or more employees. So you're not off the hook if you have 14 or 13. So anyway, we'll address that in more detail later on. Now I'm going to give you 4 definitions. And unfortunately, the first 3 of those are not particularly concretely defined. So there's wiggle room in the first 3 of these. All right, so what is a disability? A disability is defined by the ADA as a disabled individual who has a physical or mental impairment that substantially limits one or more major life activities, or a person who has a history or record of such an impairment, or a person who is perceived by others as having such an impairment. And what that means as far as being perceived or having a history of sort of like the one we just talked about a minute ago, where you've got a related person that has the disability. This is telling employers that you have to be careful. You have, let's say, an employee who had cancer, was successfully treated, took 90 days off FMLA or something like that, had chemo, whatever they had, they came back to work. So for the past couple of years, they've been back at work. Everything's been great. And now you have a job opening that would be a promotion for that person and many other people in your organization, perhaps. And you are screening the people who have expressed an interest in that job, and you see the one who had the cancer on there, and you think, you know what? This is really intense training, and it's hard to get somebody up to speed on this job. I don't think I want to consider that person who is in remission, because just in case they get sick again, but I don't want to have to go through this training process again. Well, that is an improper discrimination against someone who is perceived by others as having an impairment or who has a history of an impairment. So be aware of that this issue with disability, once again, is broad, as are the major life activities. So major life activities include taking care of yourself, like dressing, bathing, that sort of thing, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. And you're like, wow, that is a pretty exhaustive list. And it is an exhaustive list. So when you look at that, you might think, man, how do you work around those things? Well, for one thing, anyone you have that comes in that needs an accommodation is not going to have all that, okay? And so you're dealing with things one person, one applicant at a time, and assessing situations one person at a time. And so don't get all panicked about all those limitations. All right, the next definition is, what is a reasonable accommodation? Now, once again, there's no strict definition of reasonable accommodation. Basically, it's any change in the workplace or in the methodology and way you do things in your workplace that provides an equal employment opportunity to an individual with a disability. And a reasonable accommodation can cover most things that enable an individual to apply for a job, perform a job, or have equal access to the workplace and to employee benefits. So once again, kind of thinking broadly about imagining where I might experience these things, or a disabled employee might experience these things in the office. It would include making certain that, you know, if you have disabled employees, that they can reach the microwave, or that the parking lot doesn't have, you know, steps going up to the building, or if you are going to have an office party at the holidays, that you make certain that the venue at the office for the office party is accessible for people with disabilities. So there are a very broad array of reasonable accommodations. Could include modifying work schedule, enabling someone to work from home, changing perhaps a method of the way one or two duties of a job is performed, eliminating a non-essential job duty, maybe allowing somebody to take additional breaks, maybe providing accessible parking, materials in alternative format like Braille and large print, and allowing time off following FMLA. Now, interesting thing about the intersection of the ADA and FMLA, that for a number of years, these two laws came into being very close to each other in time, but it took a long time for the FMLA and the ADA to really begin to intersect in a big way. And this is a question I get regularly about FMLA. It actually, giving someone who's been on FMLA an additional few weeks of leave time can be considered a reasonable accommodation through the ADA. So be aware of that, that if somebody's, you know, returning from being out for 12 weeks, their doctor says, you know what, you need another 2 weeks and you'll be good to go, that would be considered reasonable under the ADA. And actually, there have been several court cases about, well, how much time is reasonable? And it really is pretty much undefined. You have had some courts decide that 6 months is not unreasonable. So if you experience that situation, and you know, you would say, depending on the size of your business, 6 months might not be reasonable for you, or maybe it would be for some businesses. You may have a tough decision to make. And as always, if you're talking about taking a negative action against an employee, always seek legal help in navigating that. Okay, hopefully you won't experience that, but if you do, that's going to be one of those times when you want to seek legal assistance. All right, next we're going to talk about what is an undue hardship. Under the ADA, the employer is required to provide reasonable accommodations as long as doing so does not create an undue hardship on the organization. And so an undue hardship is a significant difficulty or expense. And so you could have things that fall into two categories: just the level and degree of difficulty of that accommodation, or the level of actual cost of that accommodation. The cost of the accommodation could be an undue burden on the employer, but so could the accommodations, the duration, the expansiveness, or the disruption to your office. The accommodation would fundamentally alter, if the accommodation would fundamentally alter the nature or operation of the business, if that would be an undue hardship, then that's fine on its own, even if it didn't cost a lot. So for example, if somehow accommodating one person would cause you to have to change your office hours or enable some other major changes, that could all by itself be, well, we can't do that. That would be an undue hardship for these reasons. Even if it's, is essentially free, that would still be an undue hardship. But if cost alone is the basis, then you have to be careful, because it really needs to be significant expense before you can rule it out as an accommodation. Federal regulations instruct employers to consider the size of the organization and the facility, the overall financial resources, and the availability of any tax credits or cost deductions or outside funding that may be available. And there may be things out there that you would actually be entitled to by hiring someone who does have a disability, and then you could use the cost of that accommodation perhaps to take a tax credit or some type of tax deduction. But the bottom line importance is you have to assess the situation on a case-by-case basis. And one other interesting factor about undue hardship is this: what is not undue hardship for one company might be for another company. So for example, if you're a business and you've got 20 outside salespeople, it might be easier for you to accommodate, let's say, someone who needs to alter their work schedule, and allowing somebody to work a different work schedule from everyone else might be easier than, let's say, you're a smaller business and you only have 2 people in sales. So 50% of your workforce might be asking for an accommodation. That might be more difficult for a small firm. Same with the cost. One thing to consider when you're talking about accommodations would be a large company who may have more job openings, more jobs, more employees. If you were to make some large alteration, let's say, to the layout of your office in order to accommodate people with disabilities, they may find that additional people use that accommodation too. Once you've paid for, you've had the work done and you've paid for it, if somebody breaks their leg, an employee breaks their leg skiing and needs to be in a wheelchair for 6 or 8 weeks. Well, it might turn out that the modification to your building is actually going to be, useful to multiple people, not just one individual. And again, that might not be the case with a small employer who may never encounter this situation again. So those things can go into your decision making as to what's undue hardship and what's not. All right, now this is the last of the 4 definitions, and the interactive process. This one is fairly well defined, and this is another one of those areas where I would say open your mind, think about the definition for what this means, so that you can not just think of it as a one and done conversation. You don't just think of it as, okay, now I've done my duty because I had a 2-minute conversation with this employee. When an employee requests an accommodation, both the employer and the employee need to engage in that interactive process. And what that basically means is that you as the employer, you need to have a conversation or a series of conversations and some back and forth with the employee as to what may be a reasonable accommodation. So it is a process, not simply we met, the person's request didn't work, and so we didn't hire them. You might begin the process, employer, with the employee explaining to you, have you given this any thought, employee, and what what is your thinking on what type of accommodation? So you get to know their mind, because, you know, assumptions are dangerous things. And then you say, okay, I need some time to think about this. So can we meet tomorrow again? Or if it's on the phone because the person is not able to come into work, can I call you back tomorrow after I've had some time to think about it? And then you contact the employee again, and then you begin to discuss back and forth ideas about what can be done to accommodate this employee. So that's the nature of the interactive process. And in the eyes of the EEOC, I'm not exaggerating when I tell you that the interactive process is almost as important as the accommodation itself. And if you ever come under scrutiny by the EEOC, they're going to want to know what was the nature of your interactive process. And so you should document that very well. It should be obvious that you and the employee or applicant or whatever the situation is, that you have worked together to talk about ideas, and you've thrown out ideas. And if you've come to the conclusion that there is no reasonable accommodation, why did you come to the conclusion? You know, you might document what the employee asked for. You might document your analysis of that, whether disruption to your firm, whether cost. You might document any ideas that you had that you put out there and said, well, hey, we can't do this, but what about this? And how the employee responded to that, and you know, just their response and that sort of thing. So make certain that you've got good documentation of everything you do with the interactive process. All right, so remember that I talked about the fact that the ADA covers the entire employment relationship from beginning to end. So we're going to start with the hiring process and your job postings. And some of these are just some potential ideas or suggestions. I think most of this is not stuff that you are required to do, but things that you might want to think about doing. Some or all of these things. So the first is thinking about your job postings. I don't know how most of you advertise for employees, if you do it internally, if you go through, you know, Indeed or Ladder or whatever your methodology is as far as putting your job postings out there. But you might consider including in the job posting a reasonable accommodation statement. And basically, it's just an opportunity to say that here's what our employee does, not our employee, here is what our company does to take steps to ensure that applicants and employees with disabilities are provided reasonable accommodations. So just a nice little public relations statement, and it does give an applicant, you know, the hope that, okay, maybe I'm not going to hit a brick wall with this company. And so, you know, like I say, not required, but something that you might want to consider. Now, in your job postings, I do believe that it's very smart to list your essential functions. Now, you know, what precedes essential functions? Well, job descriptions. So your job descriptions need to include essential functions. And that means things that, at the bottom of this slide, factors to consider: whether the reason the position exists is to perform that function. That would be essential. You know, the low-hanging fruit there would be an airline pilot. All right, the airline pilot is essential to be able to fly a plane. No getting around that. The number of other employees available to perform the function, or among whom the performance of the function can be distributed. And that's where I talked about the difference between large employers and small employers, is that it may be easier for large employers to make certain accommodations because they have way more employees available to perform that function. And then the degree of expertise or skill required to perform the function. That's another thing you can consider when you start talking about essential functions. All right, so when you've done all your fabulous job descriptions, you take the essential functions and include those in your job posting. Now, the potential employee then can look at that and see, okay, you know what, all these, with a small accommodation, I can do all of these things. I'm qualified, I've got the certifications they're looking for. I don't really see, now I do see a couple, once they see the job description, and actually we're going to get to that on the next slide. Go ahead and flip over there. Once, if they see the job description, if you include the job description with the posting, they can determine with one or two little tweaks for inessential functions, I think I could really be awesome at this job. So the importance of a good job description cannot be overstated. Every single job applicant should be provided with a copy of the job description. The job description should not be secret. Your whole company, everybody in your company really should be able to see all the job descriptions. And certainly when you have applicants or anyone who says, I saw your ad, if they happen to call you or email you, could you please send me the job description? That really should not be a problem. And the written job description, it's important that that's prepared before you advertise or interview, because again, if you ever run afoul of the EEOC, things like that are going to come out, and you don't want it to look like, oh my gosh, somebody with a disability contacted me and I had to scramble to get a job description together. You don't want to be in that position. Okay, so job descriptions are important. Now, when it comes to the essential functions of a job description, I think it's important to note back in the day when I was first embarking on my HR career, boy, was it such a totally different world. There used to be these things called bona fide occupational qualifications, and actually that really does still exist, but a BFOQ, bona fide occupational qualification. But the importance there was that unfortunately, since the mid to late 60s, you had these civil rights laws, and I hate to say that there were some employers out there who still sought to screen out certain groups of people, whether based on race or gender, that you didn't want any women doing certain jobs, didn't want any people of color doing certain jobs. And so a lot of companies would add things like a college degree required to do whatever job they happen to be writing a description for, knowing that people, minorities and women and others were less likely to have a 4-year degree. And so they would throw that in there as a means of being able to screen out people that they didn't want to hire. Well, the EEOC got onto that fairly quickly. And that's where, when you start talking about your job description and your essential functions, you need to make certain that what you have on there as essential is really an essential function, and not just, if the employee once a day needs to be able to, in the morning, they've got to be able to lift this 20-pound box, and then they work out of that box all day on files and stuff, and at the end of the day it has to be put back. Moving that box would not be an essential function of that job. Okay, so if you wouldn't want to put that under your essential functions, because it would be very simple to ask the employee that sits next to this employee twice a day, could you please remove the box from the shelf, and then could you put it back on the shelf? Or you could even buy a little cart to put right beside that employee's desk and say, here, you can use this and this will work. So just keep that in mind as you're doing your essential functions. And I'm certain that I don't have any clients who would do anything, to try to eliminate hiring people with disabilities. So just keep that in mind as you're doing your essential functions. All right, now in your job posting, it might be helpful to have a physical requirements statement. Some jobs do absolutely have physical criteria that the incumbent has to meet. There's just no getting around it. If the ability to lift or stand or move heavy things, or you have to go up and down ladders, climb stairs, if that's all essential to the job, well, it might be helpful to put that in the job ad. Also in the job ad, you can put by the functions, how often do you have to do this? If it's an occasional thing, or if it's a frequent thing, it might be helpful to know that. So, you can have someone who has arthritis who could lift that box once a day or twice a day, but you could have somebody else that couldn't. And so, you might want to just put that out there, whether it's occasional or frequent, and that might help guide a person looking at your ad. Physical demands description should apply to the essential functions only, right? And applying them to non-essential functions can unnecessarily limit your applicant pool and perhaps expose you to some legal liability. Now, one other thing that you may want to put in your ad would be in your job posting, the working conditions. And really, this could apply to any number of employees with any number of life circumstances. So it helps to have advance notice of the working conditions. An example would be if the job requires irregular hours, like nights and weekends, overtime, alternating shifts. That applies to a broad group of people. For example, folks that have caretaking responsibilities, they might want to know that. It might be helpful. And they may decide, I can't do that, so I'm just not even going to bother with this person. It saves them time, perhaps saves you time. Working in unpleasant conditions, such as being outside for extended periods, working during challenging weather conditions. In the wintertime, we see all these news broadcasts. You see people out in the weather. Imagine that you work for Dominion Power and you're out there having to do things in ice conditions, snow conditions, just cold, damp. There may be people who just don't want to do that or simply cannot do that. And also, if there's a hazard involved in the working environment, your applicants may want to know that in advance. So those are just some thoughts on ways to put together your job postings. Now, we're going to now embark on the 3 stages of employment. We're talking about pre-offer applicants, we're talking about post-offer candidates, and then we're talking about how to treat employees. And I want to emphasize that what I'm about to go into is very broad brush information. This is kind of where there's a lot of questions about, can I ask people this? Can I ask people that? Before I make an offer, can I make them have a medical exam, that sort of thing? But yeah, there's a lot more to this. And if you find yourself in a situation where you happen to know, or the person has disclosed that they have a disability and would need an accommodation, or would like to talk about an accommodation, that, yeah, you may end up wanting to seek some legal advice. But here is some information that might be helpful. That with the ADA, you generally cannot ask disability-related questions or require medical exams until after the applicant has been given a conditional job offer, okay? Because in the past, this has been used frequently to simply exclude people despite what could possibly be a great employee who's perfectly able to do a job with a relatively minor accommodation. You can ask every applicant, let's go back to the easy one with the airline pilot. If your vision has to be corrected to 2020 and you don't know anything about anybody's disabilities, but you're asking every single person that you talk to, is your vision correctable to 2020? And that's all. You can ask that question. But generally speaking, you want to avoid disability-related questions before you've made an offer. Employers are permitted to pre-offer to ask limited questions about reasonable accommodation if they reasonably believe that the applicant may need an accommodation because there's some obvious reason why you might think they have a disability, or they voluntarily disclose that. You can have a limited discussion. This is where I think it's more helpful to listen than to try to respond or rebut or discuss in detail. I think that if the person mentions that they have a disability and that they would like an accommodation, you might just ask them, oh, well, I appreciate your, telling me that. Tell me a little bit about what we might be able to help you with to help you succeed on this job, something like that. And then just make a note of what they tell you. And then just after that, you just kind of leave it alone and say, well, address the interview globally or the discussion globally and not, hone in on the disability, unless they come back and say, do you think you can do that for me? Or something like that. And then you're going to want to say, you know what, we're early in the process. We certainly want to do what we can do to help you, but it requires a more detailed discussion. And so we would get to that at the next stage or something like that. You really don't want, in your mind, you don't want to close your mind and say, oops, I can't talk to this person, or there's no point in going any further with this. And you don't want to leave with the candidates, a bad taste in the candidate's mouth, thinking like, wow, I said that and now they just dismissed me altogether. Also, pre-offer employers may ask if the applicant will need an accommodation to perform a specific job duty. And if the answer is yes, the employer may then ask about possible accommodations. So for example, if someone in a wheelchair comes in to interview, and if there's a specific job duty that, let's say you have a help desk operator, and part of that is installing computer equipment, and they have, there's a need to be able to crawl under desks. You might have a conversation and say, I recognize you're in a wheelchair. And as you can see from the job description, one of the essential functions is to climb under desks. And my question would be, obviously you're currently serving as a help desk operator. Is there something that we could do to make that doable for you? And just simple kind of back and forth, no details, no judgment, like, oh, that'll never work, that kind of thing. Just try to keep it so that everyone's mind is still open. The employer may not ask any questions about the nature or severity of a disability pre-offer, okay? It's funny because when I was, again, going back to my early days, I'm sorry I give you early days stories, but I do recall, and actually it was a help desk thing, and it did have to do with going under desks, and this was before I really understood what the ADA was all about. First question I ever had about disabilities. And it was a help desk operator I had advertised for, and a person called me and asked me about the fact that he would not be able to climb under desks. I have to be honest with you, I did not have any idea how to answer that question. Now, luckily, I worked for a law firm that had a nice employment law team of wonderful attorneys that were frequently very helpful on topics like that. And I had to go to the attorney and say, oh my gosh, I'm so embarrassed. I did not know how to answer this person's question. And so, yeah, you really do have to think through, if you were the applicant, how would you like to be responded to, and try to be gracious and open-minded and approach it as, we want to help each other, because we have we have complementary goals. We want to end up with a good employee and you want to end up with a good job. And so we need to discuss further accommodations, and that comes in the next stage. All right, now post-offer. Now, after you make a conditional offer of employment, now a conditional offer means that here's the job, we're offering it to you, here's the salary, here are the benefits. Now, we have some housekeeping things that we have to get through before this offer becomes a regular job offer. So for example, we're going to do your background screening. That has to come back satisfactorily. And we may have medical exam that we need to get the results back from, and that sort of thing. So yes, you're able to do all that once you've made a conditional offer. And then if the person cannot pass the medical exam, depending on what the problem is, you may be in a situation where you do need to start talking with the person and have an interactive dialogue about what type of accommodations could be made. There may be situations where you simply cannot, there is no reasonable accommodation. And as you know, a lot of that's going to be determined by what the essential functions are and what the person's disability is. Anything that you glean or that you receive from medical information, per medical information, has got to be kept absolutely confidential. Employers may give what's called a POMQ, a post-offer medical questionnaire. Now, once again, remember, when you're talking about post-offer but pre-employment, you have to treat everybody the same, all right, for that job. So you can't single out the person with the disability to get a medical exam or to answer this POMQ. You have to do this with everybody, but it's fine to do it with everybody. Once everyone you've made an offer to, you can get them to fill out the post-offer medical questionnaire, and that may help you assess if the candidate is physically able to do the job, remember, with or without a reasonable accommodation. And once again, you need to make sure that all your candidates have that job description in their hands. All right, now with employees, what do we do? General rule is that disability-related inquiries and examinations of employees have got to be job-related and consistent with business necessity. What that means is you simply cannot randomly pick some employee who appears to be tired every day and make them go, get a physical, or do you have a disability? It's got to be related to the job, and it's got to be consistent with business necessity. The ADA does not require employers to continue the employment of an employee who can no longer perform the essential functions of the job. Now, if I have ever read what sounds like a heartless statement, that sounds like a heartless statement. And so, in my opinion, if you believe that someone is unable to continue the essential functions of the job, I think you've got a process to go through. Number one, you need to focus on job performance, okay? You don't need to be having an opinion about, like I said, they've been showing up looking tired every day, or you thought you saw somebody napping at their desk on a couple of occasions. Instead, if someone has been tardy, now you've noticed 3 times in the last month, then you go to the person and say, wow, I noticed that you were tardy on these 3 days, and that's not like you. Are you doing okay? Do we need to talk? And let the employee tell you, no, it's because my child's school schedule changed, and now I can't drop them off 10 minutes early like I used to. Okay, that's easy enough. That's not an ADA issue. But that's the way that you work your way around to trying to figure out if someone has a disability situation. I was reading an article through SHRM the other day about employees with early onset Alzheimer's, and it's really heartbreaking to see people in their 40s and 50s who are already showing signs of Alzheimer's, and how the employers deal with that. And it can be difficult, but I'm going to say that certainly compassion is one of the operative words, where you treat the employee with compassion. You try your best to help the employee. You may end up having to have a reasonable accommodation if the person tells you, I've been diagnosed with cancer, and I've been having some treatments that are, they're making me tired. Oh, yeah, okay. That's a reasonable accommodation discussion, and it could be an FMLA discussion as well. And so you want to help this employee get back up to speed and be all they can be. And so, you're now in help mode. And that's kind of the way you want to approach the situation with employees who may or may not be able to perform the functions of the job. I've heard of people who have glaucoma or something like that that's interfering with their vision. And, in the long run, there may not be a lot you can do for that person, but at least having that interactive discussion is going to go a long way, and being compassionate. And, that includes talking about your short-term disability benefits, your long-term disability benefits, even distributions from 401ks and that sort of stuff. So anything you can do to be in helpful mode is usually very much appreciated by your employees. Okay, now the employee has what's called the duty to inform, and this is a lot like FMLA. Reasonable accommodation and undue hardship provides that, as a general rule, the individual with the disability, and that's the person that knows the most about what their condition is and what they might need, they need to inform you that they need an accommodation. And they can either request it verbally or they can put it in writing. And remember, they don't have to say, I have a disability and I am hereby requesting a reasonable accommodation under the Americans with Disabilities Act. They don't have to say any of that. They can simply tell you what they're wrestling with. And if it fits those life activities that people can't do, then now you're in an ADA interactive dialogue situation where you need to start talking with the employee about accommodations and that sort of thing, and the interactive process, and you need to initiate that. So remember, your employee does not have to use any magic language. So you'll notice I've got down there, however, the employer must initiate the interactive process under certain circumstances, even though the employer has not received a request. So when should you initiate? All right, if you know that the employee has a disability. Now, this could be something where somebody needs a minor accommodation. You're aware that they've got whatever the problem is, and it may be long-term or short-term. And you just may say to them, look, you told me last week that you have this condition. I just want to make sure you know my door is always open, and that if we can accommodate you in some way, then by all means, let's sit down and talk about it. And if the employee goes, no, it's okay, it's no big deal. I'm getting along okay, I'm taking medicine and everything's fine. Okay, but let me know if things change. Also, in that situation where I talked about the employees with Alzheimer's, that you are realizing that maybe this person doesn't really know to ask for an accommodation. Something is clearly wrong with Bob, and I need to talk to him about why he's really slipping. He can't remember anything. He keeps showing up to meetings late. Well, you need to, as the employer, take the initiative and initiate that accommodation interactive process, and just simply say, focusing on the work performance, you really seem to be struggling because here are the things we've observed, and you're in a tough spot if the employee is kind of in denial and doesn't really know that these things are happening. And what do you do then? Well, you might suggest we have an employee assistance program, and you get, explain to them what the benefits are of your EAP. Try to get them, to go in that direction, and maybe a doctor will recommend. So after that stage, if the person's still not kind of taking that bait, I would probably call a lawyer and say, look, can I contact their relatives? Is there any recourse I have here? Tell me, what should I do in this situation? Because this person cannot continue doing this job. He's a danger to himself and to others, but I don't want to just fire him. So at that point, that would be another point where you might interact with a lawyer. All right, things the ADA does not require. It does not require you to hire an applicant who's not qualified. All right, so if you need for somebody to be a CPA, and that person is not a CPA, and they haven't even graduated from college in accounting or anything, you do not have to talk to that applicant, okay? Because that's probably an essential function and something that's very reasonable to have on your job description. So you do not have to hire people who are not qualified. You don't have to provide the accommodation of the employee's choice if there's another reasonable accommodation that can be made. So if somebody asks for this accommodation, and like, I'm uncomfortable in my workstation, so I want to be moved, please. I noticed that there's a window office over there with a bigger desk and a more comfortable chair. I want to move into that office. Well, what you could put out there alternatively might be to say, look, here in your space, we can put that same desk and that same chair and leave you in the space you're in right now. So as long as that's all still reasonable, then you could do that instead of moving the person into the window office. You are not required to make an unreasonable accommodation. We've talked about unreasonable accommodations, and I think probably sufficiently. You are not required to remove an essential function from a job description as an accommodation. And again, you're not required to retain employees who cannot perform the essential functions of their job because of a disability. All right, I'm going to do a quick Q&A, and then we're going to move on to the pregnancy protections. All right, what if I have personal experience with this disability and I know this person is not going to be able to successfully perform the job? No, every situation has got to be assessed individually. There could be factors there that even though you had a relative that had the same thing and couldn't do this and couldn't do that, you have to talk it through and have that interactive dialogue. So just don't make assumptions about what people, and don't generalize about what people can and can't do. All right, we've already answered this. Am I required to hire someone with a disability even if they're not qualified? Okay, simple answer, first word, no. People have to be qualified to do the job. How does the interactive process work? I think we've talked about that sufficiently. It mainly involves conversation, talking, give and take, back and forth, trying to just brainstorm and come up with things that could work. Do I have to make the accommodation of the candidate's choice? Nope, we've talked about that. Maybe good reasons why you cannot or should not do the accommodation that the employee wants. And it could be that there will not be a reasonable accommodation. Now, one thing they suggest in this answer is you might do a trial period and make it clear that for the next 30 days, here's an accommodation that we're going to try, and we're going to assess it at the end. It may not work for us, it may not work for you, but if it doesn't work, then we're going to have to go back to the interactive process and see if there's anything that will work. So whatever the outcome, the importance of the conversation cannot be overstated. Is an interactive process always necessary? That's a really good question, and the answer is no. If the person has if there's an obvious accommodation that can be made, then there is no extended discussion required. And they use the split keyboard. It's funny, at a company where I once worked, wow, you had to go through a lot to get a split keyboard, and it kind of like was unnecessarily grueling the process. Eventually, when enough people, a lot of people out there have carpal tunnel, requested these, well, then the company's like, okay, you know what, we're just going to have a choice. We're going to stock both the split keyboards and the regular, and whichever one people want is the one they're going to get. So, no more having to wrestle with people over that low cost, easy solution. Same with, chairs. People with varying ailments might need a specific chair. And honestly, I know of certain circumstances where the employer has just simply said, you know what, here's our price point. You find the chair that you want, and we will buy it. And that's just the way it worked out. Didn't have to go through a long harangue or anything like that. It was just fairly easy to make an accommodation for the chair. Now, it might not match your decor and that sort of thing. Sometimes you just have to put aside things that are really, in the long run, kind of inessential in order to make it an accommodation work. All right, now we're going to move into pregnancy-related protections. And this is a little bit confusing, and it may be eye-opening to you. Anyways, just to me, it's kind of interesting. Having been a mom myself and having been in the workforce for the past 50 plus years, you have several different pieces of legislation. You have the Pregnancy Discrimination Act, you have the Pregnant Workers Fairness Act, and then you have the PUMP Act. Oh, isn't that clever? Providing Urgent Maternal Protections for Nursing Mothers Act. And then we have, those are the federal protections. Then we're going to talk about the state. All right, so just kind of quickly to run through these things. Back before 1978, you really didn't have any job protections for pregnancy. You just didn't. But after the Pregnancy Discrimination Act came about, that was added to Title VII. And that list of things in Title VII, age, race, national origin, religion, and that sort of thing. Well, pregnancy was added to that. Now, basically, though, all that it did not affirmatively require employers to accommodate pregnancy or pregnancy-related conditions. It simply said that you have to treat pregnant women just like you treat everybody else. All right. And so if you didn't allow people to have drinks in their workstation, then you didn't have to allow pregnant women to have drinks in their workstation either. Or bathroom breaks. If you only allowed one bathroom break every 3 hours, you did not have to make any more bathroom breaks for pregnant women. So, it kind of like, yeah, it did mean that somebody couldn't look at you when you're in the interview chair and go, oh, I see you're pregnant. Well, we're not going to hire you in that case. Yeah, it prevented that sort of discrimination, but it didn't prevent other, forms of discrimination. All right. Then the Americans with Disabilities Act came along, and you might say to yourself, hey, that's awesome, because now there may be some pregnancy protection. Well, I'll tell you that most of the time, pregnancy is not a disability, all right? I don't know about any other ladies out there who are moms, but, I can remember before I was pregnant, I walked 5 miles a day, and then for the whole duration of my pregnancy, I walked 5 miles a day. I did not consider myself disabled in any way, and I don't think anybody else generally did. So in reality, the ADA, it may be useless to many or most pregnant women, only if you develop some condition, perhaps pregnancy related, that really now would be classified as a disability. Now you get disability protection. All right, and now we have the PUMP Act. We have this is an amendment of the Fair Labor Standards Act, and it requires employers with 50 or more employees to provide time and space for breastfeeding mothers, okay? The Affordable Care Act already requires employers to provide reasonable time to express breast milk and a place for pumping other than a bathroom, cannot be a bathroom, has to be shielded from view, has to be private. However, this prior lactation law did not apply to all workers. Most of your management, anyone who is an exempt employee, did not apply to exempt employees. Now, so the PUMP Act basically affirms those rights as far as the milk pumping and that sort of thing, but it also covers almost all of your pregnant employees. And those breastfeeding rights include or are up to the first year of the baby's life. So now all of your employees who are nursing children get, at least for a year, you get to take advantage of this law. And then, effective coming up here in June, the Pregnant Workers Fairness Act. That requires employers with 15 or more employees to consider employee and applicant accommodation requests related to pregnancy, childbirth, or related medical conditions. Do you note that language, that accommodation requests? So simply because you are pregnant, you have the right to certain accommodations. So this is the big leap forward where pregnancy itself is actually a protected state. So you have to have the same interactive dialogue that you have with somebody under the ADA if they want to talk about, accommodations. A reasonable accommodation could be placing a qualified employee. I'm sorry, let me back up. Sorry, what's not allowed? Placing a qualified employee on leave of absence, so forcing somebody to leave the workplace if there could be some other reasonable accommodation option. Okay, so that's why you have to have the interactive dialogue. And then retaliating against employees for seeking or taking a reasonable accommodation. So always Title V of the ADA applies to, or it includes retaliation. And this is not just the employer retaliating against an employee, like you're sick of dealing with this woman and so you're going to demote her or you're going to fire her or you're not going to give her any hours for the next 3 weeks. But it also includes management, other employees, moaning and groaning and giving them the cold shoulder and that sort of thing. So really training for your managers is important when it comes to this sort of thing, because you don't want anybody retaliating against, your pregnant, any protected person. You really shouldn't have retaliated against anybody, but sometimes people have legally protected status. All right, reasonable accommodations under the PWFA, similar to the ADA, but different because pregnancy is only temporary. So something that might have been deemed reasonable under the ADA might not be reasonable under the Pregnant Workers Fairness Act. So for example, a big workspace modification for an employee who is pregnant might not be reasonable, whereas it could be reasonable, because if the person has an ongoing disability, that person might be with your company for the next 15 years. And so in that case, some type of workspace modification might be very well worth it. But unfortunately, all of this, as you know, it will probably play out in the courts, and also hopefully in further helpful guidance from the EEOC. They do issue updates and Q&As and that sort of thing on a pretty regular basis. It's almost like the rule gets out there and then people start seeing, okay, what's practical and what's not practical, and then the EEOC issues additional guidance based on actual real life experience with the rule. So a reasonable accommodation might be allowing a pregnant employee to sit, allowing drinks or even food at the workstation, taking more frequent breaks. I'm a big fan of common sense. Just want you to know that. Common sense is your best friend. If it's something small and you can just give in on it, I'm going to say just do it. And I know that as an HR director, that adds one more thing to your day to say, oh my gosh, what if now 6 other people ask for this? Well, 6 other people are probably not pregnant, and you can very easily just say to them, this is a temporary accommodation that we're making under this rule. And then don't forget how you've treated employees with other medical conditions. Now we go back to treating, pregnant people in the consistent with how other people have been treated. So if you did in fact allow somebody who came back from, recovering from their broken leg, if you allowed them to sit down while they were recovering from the broken leg, then you need to allow that pregnant employee making that same request to sit down, because other people have been treated like that. All right, and again, don't forget the interactive process is required. All right, just a real quick recap, and I guess I put this in here for my own self because I kind of like to see the evolution of the protections. So before 1978, we had virtually no protection. In 1978, we got some protection, basically just treat the pregnant person like everybody else. And then we got the Pump Act and the PWFA. So gradually we're moving forward, I would say, in our enlightenment as far as how to treat pregnant women. And hopefully now it'll just, employment will just be a better experience for women who are trying to juggle having a career with having a family, nursing a baby and that sort of thing. Just try to make things a little bit more just easy on people. All of the laws we discussed are at the federal level, and now we're going to head into the state laws. All right, now remember, this is Virginia. There's a Virginia Human Rights Act, and there is a Pregnant Workers Protection Act. So you have obligations under both of those. And what is important here is that this applies to employers with more than 5 employees for a 20-week period in the current or preceding year. And that means you must provide reasonable accommodations for otherwise qualified persons with disabilities. I'm sorry, I should have said we've switched gears now, we're back to disabilities. If necessary, to assist such a person in performing a particular job, unless the accommodation would impose an undue hardship on the employer. This is, for all practical purpose, very similar to the ADA. Almost, if you go down the line with the main requirements, these two are very, very similar. The huge difference could be the 5 employees under the Virginia Human Rights Act. Okay, so basically, if you're an employer between 5 or 6 and 14 people, you now have a disability law that you have to comply with, whereas a few years back you did not, because you didn't have enough employees. So essentially, you're prohibited from taking adverse actions against the employee, denying employment or promotions, or requiring an employee to take leave if another accommodation can be provided. So just remember that you can kind of look at this as a Virginia state ADA law for employers with more than 5 employees. Here is a poster that you are required to post, Virginia Human Rights Act reasonable accommodations. You can find this on the internet and print it out, or I can make a note and we can send this to you with our PowerPoint. Now I'm going to recommend, if you're not doing this already, that instead of trying to cobble together all of your state and federal posters that honestly, yeah, they might cost a couple $100, but you go to one of those poster services and they'll send you all of your posters together for a fee. And like, I would have that on my to-do list for every January. I would just order a new set of posters, to be honest, because there's so many things on there now. And the likelihood that not one of those things changed during the past years is probably not great. So anyway, this is available from a poster service combined with all your other posters. All right, reasonable accommodations, very similar to the ADA. Modify work policies, allowing people to use leave, reassigning to a vacant position, acquiring or modifying equipment, assistance with manual labor, which once again is where your job descriptions come in, restructuring the job, modified work schedule, using light duty assignments. All those things have been considered reasonable. So now that doesn't mean that all of these are going to be reasonable in every single case. It just means that when you have your interactive dialogue, you probably want to have this little list out beside you to make sure that you, that you know what's been construed as a reasonable accommodation. All right. Yeah, now as we've said before, same interactive process. It must be timely, it must be good faith, and maybe what the employee is asking for is not going to be reasonable, but you need to have a discussion about alternative accommodations that may be reasonable. All right, now it provides limited protections for pregnant employees. Safeguards all individuals, and again, just like with the federal law, it adds pregnancy, childbirth, and related medical conditions to the state protected list. But it does the same thing basically, that says you can't discriminate in employment, adding pregnancy and childbirth to the list of things that are protected, but does not give protected status just because the employee is pregnant, or doesn't give any additional benefits. The terms because of sex or gender, or on the basis of sex or gender, or terms of similar import when used in reference to discrimination in the Code and the Acts of the General Assembly include pregnancy, childbirth, related medical conditions, including lactation. Women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all purposes as persons not affected but similar in their abilities or disabilities. So notice there are no protections specifically for pregnancy. So now, though, however, we get into an amendment to the Virginia Human Rights Act, which took place or effective July 1st of 2020. Once again, employers, now this time with 5 or more employees for the 20-week period, now you must provide reasonable accommodations specifically for pregnancy, childbirth, related conditions, including lactations, unless the accommodation would oppose an undue hardship. So now you have affirmative steps that you must take when you have pregnant women asking for accommodations. All right, now you get another poster. This is specifically the Human Rights Act, Virginia Human Rights Act, for reasonable accommodations for pregnancy. All right, so this is separate from the other one that looked just like it, because you'll notice it says pregnancy at the top. And once again, if you use a poster service, you can get this along with your other posters. All right, now, examples of reasonable accommodation for pregnancy: more frequent or longer bathroom breaks, breaks to express breast milk, and access to a private location other than a bathroom for the expression of breast milk, acquisition or modification of equipment or access to a modification of employee seating, a temporary transfer to a less strenuous position, assistance with manual labor, job restructuring, modified work schedules, light duty assignments, and leave to recover from childbirth. So those may be now reasonable accommodations for pregnancy. And a lot of this just mirrors the federal law. And so basically, if you kind of use your head about what you should or shouldn't do, and then you go back and review these lists of accommodations, you are going to be on pretty sound ground. Now, interactive process, we talked about this, about you must engage in timely and good faith, and if what the employee is asking for is not reasonable, then have the discussion about what might be reasonable. Now, employee handbooks and conspicuously displayed posters must notify workers of the right to request and receive reasonable accommodations during pregnancy. This does not mean that you have to have an employee handbook. It means that if you do have an employee handbook, you need to put this notice. Basically, you could probably just display the poster in the handbook. And then, just like with your other posters, you got to put these posters in a conspicuous place or places, or displayed online. Also, when an employee discloses her pregnancy to the employer must verbally offer within 10 days of the disclosure to provide a reasonable accommodation. So you're going to want to talk to this employee and say, congratulations on your pregnancy. Remember, being nice goes a long way. And then say, sometimes pregnant women need some accommodations. So hopefully you'll have a smooth and easy pregnancy, but just in case, the door is always open. If you have any issues, we need to sit down and talk about how we can make things easier and accommodate your situation. All right, here's some miscellaneous that you may not ever have thought about. Just one. Title I does not address the use of service animals from employees. However, a request to utilize a service animal should result in an interactive dialogue, just like any other request for accommodation. Now, one thing to consider is that if you operate a business and you allow customers to come in with service animals, it's going to make it way harder for you to say that no, an employee cannot have a service animal. So just remember that. All right, so here's just could be a list of helpful questions. I really would be curious to know if anyone out there has ever had an employee asked to bring a service animal into the workplace. Here's a list of questions, just common sense stuff, and you're going to get a copy of this slide along with all the others. And we've been going on now for over an hour, so I really probably don't need to read all of these. But some of these are like liability limiting questions, and some of these are things that you really would want to know about an animal, because there have been some pretty wild requests out there, like your service pig or your service monkey. So these are just good things to consider, because you do have the interests of your current employees to consider, as well as any liability issues. And once again, this is going to be another one of those areas that if you get down to where there's no accommodation you can make that satisfies everybody, you're going to need to talk to your lawyer about how to make it happen. Did I say I'm a fan of common sense? Haha, yes, I did. All right, be prepared. Okay, educate yourself on the basics of Title I mostly. Title V, for the most part, is don't retaliate, don't have a culture of retaliation in your company, and don't allow employees or supervisors to retaliate against anyone on the basis of a disability. Title I is the one with more heft that goes into all the details. So review Title I, lots and lots of stuff out there on the internet about it. And remember, don't forget about your Virginia law, and overlook that, because that's equally important. Understand, which is really important, opening your mind, clearing your mind to understand that you and the person requesting an accommodation, you're not adversaries. You're really working toward complementary goals. You want a good employee. The prospect or the employee wants a job. And so, as challenging as it can be, perhaps sometimes, you need to try to think of it as we're trying to work together here to come up with something that works. Sometimes that is not going to be fruitful. You simply are not going to be able to come up with an accommodation, but you need to give it everything you got to have that dialogue and to come, to some type of harmony if you can. Understand that a reasonable accommodation enables an otherwise qualified person to succeed at a job. And that's really what you're looking at is, I may get a really outstanding employee if I can overcome this minor barrier or this barrier. Never retaliate against someone for asking for an accommodation. Okay, that means don't take big actions like firing or failing to promote. It also means don't take or allow subtle actions like making snide remarks or being unfriendly. Train your supervisors on the dangers of retaliation. Now, one thing I would suggest here is to sit down in your free time, and maybe make a list of across your whole career of times when your employer or you have accommodated somebody's disability request. I actually did that, and I was very surprised to see how many things that employers had done, and even some of these even predate legal requirements, but just how refreshing it is when employers really try hard to just remove little barriers. Things like, a person with hearing impairment, just buying a little device that goes on the telephone that opens up the whole world of easy phone communication for this employee. How easy was that? You know, offering people a choice of chairs, offering people a choice of keyboards, moving a microwave down to a lower shelf. That was one that one of my employers did one time. It was just so easy. We're just going to move that one down a little bit, and there, voila, it was taken care of. So I do not have my list with me, but I was very surprised. There must have been 8 or 9 things on there that were not terribly expensive, and yet enabled the employer to have a really awesome employee. And that's our goal, I think. All right, I'm going to thank you for your participation and see if anyone has put any questions in there. I did not, and I apologize for this, that I failed to talk about questions here. Let me open up. Sorry. Okay, I do have a question. What if the employee does not make an official request for an accommodation? Yeah, that's a good question. If the employee, that kind of falls under you know, you've got those dual obligations. The employee is supposed to initiate the conversation, but the employer also has a duty to broach the topic of accommodations, even if the employee does not. And using care. Now, if this is a known disability and this person has made it crystal clear that they have a disability, then you're probably on sounder ground to go. If you can, like, if you perceive a work problem, that you can see they're having a problem at work, to go to that person and say, look, I can see you, to me, it looks like maybe you're struggling with this or that. Can I help you? Can the company help you? You don't necessarily have to use the word accommodation, but if that person says to you, you know what, I've been thinking about it, because you're right, I've been struggling. What do you have in mind, employer? And that would trigger you to say, you know, we need to sit down and have this thing called a dialogue, so we can try to figure out if there's an accommodation that we can come to agreement on. So yeah, it can be specifically requested by the employee, or it can be initiated by the employer. You just have to be cautious about, you know, the words you use. Like, you don't want to be mean or unintentionally demeaning, like, oh, you know, because of your disability, I can see you've been struggling to get in here. You don't want to say something like that. You know, you want to be more diplomatic about it. But yes, you can definitely broach the topic. All right. Will the recording be available? Yes, it takes us a couple of days to get the recordings out there, and we will also be emailing you the copies of the slides, and also I'm going to try to include the posters in there as well. So remember, I showed you pictures of those 2 posters that you need to include with your other posters. And I think that is all for today. And I really, truly thank you so much for all of you who have stayed with it till the end. You know, as always, our webinars seem to take a bit of time, but I hope that you've gotten some worthy information out of this. And I do truly hope that if you have a question or an issue that comes up, I do my best to help you. You know, sometimes my answer is sorry, but I'm going to have to tell you, you need legal help on this one. But certainly I'm always happy to talk to you and at least try to, you know, give you a sounding board so that we can talk through what you might need to do and help you in any way I can like that. So until next time, I'm wishing you happy trails and hope that the remainder of your week is awesome. Thanks so much.